Florida Bar versus Went For It Incorporated, 515 U.S. 618, 1995, also known as Florida Man's Marketing SNAFU, was a United States Supreme Court case. This case was a balancing act between the privacy of private citizens and the commercial speech of lawyers. When it comes to the First Amendment and the Fourth Amendment, there have been many clashes in the courts. However, the Supreme Court doesn't like to put an emphasis on which right is greater. The order of the Bill of Rights doesn't dictate the order of importance, so neither should any law. What often happens is that the Supreme Court chooses to regulate an incredibly narrow portion of one right depending on the context, of course.
Like all law cases, context is necessary in order to understand why this case got as far as it did. We're going back to 1989. The Florida Bar had recently finished a 2-year survey about the public opinions of lawyers. What they found was shocking, at least for them. Most people did not like lawyers. There are several reasons that people have low opinion of lawyers. A few choice reasons were the lawyers not looking for the best interest of their clients, solicitation issues, and other forms of malpractice. The Florida Bar took that information into consideration so that it could help mitigate public perception of lawyers. The Florida Bar had already taken previous measures to curb their problem with lawyers, so they decided to tackle another mounting issue. Directly advertised mailers were allowed since 1987, but the bar felt that some things needed to be changed. They decided to partially overturn mail solicitations targeting personal injuries or accidents. A 30-day advertising blackout period was mandatory for victims for a disaster or accident. Lawyers weren't allowed to advertise directly nor indirectly to victims until the 30 days transpired. In 1992, Florida lawyer G. Stewart McHenry and the Legal Referral Service Went For It Inc. filed an appeal to the Florida District Court. He claimed it violated their freedom of speech. We'll get back to that point later, but it does play an important role. For some reason or another, McHenry was disbarred and a new lawyer, John Blakely, took over. The courts used Bates v. State Bar of Arizona as a basis for their proceedings. Bates v. State Bar of Arizona was a landmark U.S. Supreme Court case that allowed lawyers to advertise their services. It clarified that a lawyer advertising was considered commercial speech, which is protected under the First Amendment. The district court ruled in Blakely's favor, as did the 11th District Court. The Florida Bar appealed, and the Supreme Court decided to review the case. During the proceedings, the Supreme Court put the Florida Bar under the fire by making them prove the necessity of their law. The First Amendment requires narrowly tailored laws. Strict scrutiny whenever a state decides to regulate a form of speech. Intermediate scrutiny is a form of judicial review that the courts use to test statutes of constitutionality. It is only used if the state or federal government passes a statute that harms protected classes. There are two key components to intermediate scrutiny. The government must have an important interest and the law must be substantially related to the interest. It essentially means that the government needs to have a good reason for why the law is designed and why there is even a need for government intervention. Narrowly drawn refers to the legal concept of a narrowly tailored laws that least restricts the freedom of speech as possible. However, they still try to maintain their purpose. The government has to create laws that are very narrow in design so as to not become over-encompassing. It serves mostly to prevent any specific law from over-regulating an interest. The Florida Bar argued that there was a substantial interest in protecting the privacy and the tranquility of personal injury victims and their loved ones against intrusive, unsolicited contact by lawyers. They also argued that what the mailers were doing negatively affects the administration of justice.
Now, we're going to talk about the legal history portion of this case. It's going to bring us back to commercial speech. When it comes to the First Amendment, there are a number of tests in place that the Supreme Court uses to validate the constitutionality of a particular law. A test some people might know is the clear and present danger test. It basically prevented people from saying or writing things that could cause danger or civil unrest. Think of it as saying fire in a theater or a library. That's where it bases itself upon. It was later replaced with the eminent lawless action test in Brandenburg versus Ohio. The test used in this case is called the Central Hudson test. It breaks down into 4 components. Commercial speech can't be misleading and has to concern lawful activity. There needs to be substantial government interest in regulating that form of speech. It then needs to advance government interest as previously claimed. The regulation also has to be narrowly tailored. All 4 aspects have to be followed, otherwise the regulation is unconstitutional.
In a 5-4 vote, the Supreme Court ruled in favor of the Florida bar's regulation. Justice O'Connor delivered the court's opinion and was joined by Rehnquist, Scalia, Thomas, and Breyer. They argued that the law passed the Central Hudson test. O'Connor said the ancestral record mustered by the bar is noteworthy and its breadth and detail. Justice Kennedy wrote the dissenting opinion and was joined by Stevens, Souder, and Ginsburg. They felt that the bar's blackout didn't pass the Central Hudson test. Kennedy was also concerned that people in dire need wouldn't be able to get the legal assistance they needed. Kennedy argued that our cases require something more than a few pages of self-serving and unsupported statements by the state to demonstrate that a regulation directly and materially advances the elimination of a real harm when the state seeks to suppress truthful and non-deceptive speech. Both sides were referring to the hundreds of pages of personal ancestral evidence from the North Floridan citizens. The Supreme Court wanted to uphold the privacy of the victims and conceded that the law was narrowly tailored and passed a strict scrutiny test. The precedent created is that states can limit the commercial speech of lawyers in this circumstance. However, the blackout was limited to no more than a month. Other states followed suit. More importantly, though, it created potential precedent that the collective actions of an organization, field, and so on can get their speech regulated. Because people were frustrated with lawyers, the Florida bar pushed this change. Who's to say that this couldn't affect another field? Small acts like these can be used as the foundation for future Supreme Court cases. Additionally, is ancestral evidence really enough to regulate speech?